I do think the Landsbergs will probably be on this soon too, is my prediction. I see you got here early to get a good seat, Pamela.
Same here.
Larry seems to be having technical difficulties. Oh, finally he connected. You might want to unmute yourself, Larry, if you, but you don't have to.
There it goes. Hello, hello, hello.
Hey, yeah, Larry and the Dean. Yes, yeah, muting. I don't need to have people muted.
I'm better to be muted. Bill, how are you? Thank you for staying up to this late hour.
Oh, it's all of like 7:55
I know,
here
I
in
know.
the East.
It's
Well, I'm usually up much later, much later.
are you a night owl?
Yeah, oh yeah.
Okay, good. Well, good. We appreciate you being here.
And
Well,
Bill, will you stop
I
at the
don't know if
top?
you looked at the PowerPoint, Larry. I think I included you as a CC.
I,
As you
I
see from
did.
the PowerPoint, I really enjoyed doing this.
This is really
PowerPoint was very fun for me to do.
thank you.
Nice to see you, Marcia.
Mike, do I have to go put a tie on? Are you okay? This is a McGeorge. See, it says McGeorge here.
I think
It,
that's better than a tie.
There
yeah.
you go. Thank you.
Better than a tie.
I'm on
I will
brand.
concede this is the first time I've worn a tie in about 2 years.
That's awfully nice of you. Unnecessary.
Well, it's not a terrible thing, but COVID kind of cured me of wearing ties. I just stopped wearing ties, Zoom teaching on COVID, and I never really got back into it. But in honor of McGeorge and Dean Shaper and all of that, I'm wearing a tie. And if I had a McGeorge t-shirt, I'd probably be wearing a McGeorge t-shirt with my tie.
I have too many.
That happens.
Well, I know we're being recorded, so I'll say some gratuitously bland things. No, I'm not kidding. Larry, I think you might have seen it as well. I really think you all have done a great website. The Centennial, well, I thought I would Google that and see what was on the website. I think the website is really it's very well done. It's very illuminating. I love, there's a list of a lot of alums that I thought was very interesting. Um, and and you need to add Andy Puno and some others that are on my list, maybe. So I thought that was really great. And I think this idea of celebrating the 100th year of the law school's existence through a series of sort of events and lectures and so on is a great idea. It's something that other law schools should do as well. So it's a great example.
Thank you, Bill. Andy might join, and he said he had a 4:30 meeting, but he is hopefully going to join. I sent him the link, so hopefully Andy will jump
Well,
on.
people can obviously join whenever they feel like it. They can come and go. Um,
He says that you've been in touch with him.
Good. Yeah, oh, yes, I sent him a draft of the article.
It's awesome.
I didn't send him the PowerPoint. I would have if um, um, I had thought about it actually.
Oh, I could send that to him.
Why don't you do that? But please go ahead and do that. I don't see why Andy wouldn't be happy about the PowerPoint.
Oh, he'll be fine with it. I'll make a note.
You know, the one time I met him, you know, I corresponded with him, telephone a little bit, but I actually met him for the better part of an afternoon in the McGeorge cafeteria,
Yep.
which which I've been to on more than one occasion. And so I was waiting for him or maybe just hanging out there afterwards and was so impressed. I don't know whether that had been a recent development or what, but all of the um, uh, photos of, I guess, judges, a lot of them were judges, just dozens, if not hundreds, of judges who are McGeorge alums. I thought, my goodness, I don't know that there's a law school in America that has produced as many sitting judges, or maybe sitting or retired judges, as McGeorge. I don't know the answer to that. I would say McGeorge is either the winner or it's right up there in the top cluster of them. It's really an amazing number. And of course, those of us in the East think that California shoots the moon, that you have progressive statutes, you have judges that, you know, actually are interested in governance and in statutes working rather than tearing down statutes. And so we're very enthusiastic about the quality of judging by and large in California.
You could always move to Sacramento. You do have a family here, so you know.
I love Sacramento. I could easily, but we have a partner in a house in Washington.
There is that little issue, yeah.
And Don's career is totally East Coast. He loves going to the West, but his career is New York and Washington, totally East Coast. And we have a lovely house in Washington. So I love my house in Washington. And it is the nation's capital. So, you know, Sacramento maybe is the capital of the most admirable polity in the world. But the United States is a bigger polity, even if it's not always as admirable.
Fair enough.
It is. I love California. You all are an amazing state. Well, and maybe we'll see if California, you know, produces the next president.
We will see.
It's been a while. Because I think your last one, well, of course, Reagan was your last one, I guess, right? And then before that, Nixon ran for president from New York. So he didn't quite count as the California candidate in 1968, though he did in 60 maybe.
And we are stuck with his library.
Oh, are you?
Yeah. No, California is.
Oh, yeah, California is. Oh, I would think that Nixon was a very important president. I think that's magnificent. Nixon did a lot of great things. Now, he was morally squalid and almost certainly should have resigned as president. But look, you know, Nixon created the EPA. He negotiated landmark environmental statutes. His Department of Justice was relatively pro-civil rights. I believe he supported the ERA. Détente with China, normalizing relations with the Soviet Union. You know, his attempted exit from Vietnam was maybe not one of the high points of his tenure, but Richard Nixon was in many ways an excellent or outstanding or whatnot president. He had both highs and lows. He had big pluses and big minuses, I think.
I think that's how my faculty would describe my deanship. So,
oh, I don't think so. I don't think so.
Yeah, we'd have to search for the pluses and minuses, right? We were saying, Mike. Yeah. All right. Well, this is great. Good turnout.
This
Yes,
is.
since I'm letting some of these people in. You've got a wild card with
Oh,
me.
oh, they gave you the button, Bill, to, oh my goodness.
Well, I'm a co-host. To do the
We get-
PowerPoint,
We're
if
giving you the power.
to do the PowerPoint, I need to be a co-host to share it. Though Judy has a copy of the PowerPoint as well. And the dean has a copy, so you're not entirely dependent on me. But
Well, now I see how some of these people got in because you're very permissive.
Hey, Larry.
Hello, Victor. VZ Blue Air iPod. Thank you for joining us.
Thank
So
you for bringing it.
we'll get started in about another 3 minutes, folks.
Well, I'll just say I'm really, really appreciative that this is one of the topics of one of the talks using for the Centennial, since, as Larry knows, marriage equality is the reason I went to law school.
Yeah.
thank you. Thank you so much. Well, California ends up being the most important state. Now, here in the East, I was involved in Massachusetts and Connecticut. We think they were great. But California, in the book that I wrote on marriage equality, which is right here.
Oh, there you is. All right.
It's a pretty Zoftic book. And one reason it's Zoftic is that it really does cover what went on in California, which was longstanding, complicated, and terribly, terribly important. So California ends up being the big star, and as we'll soon see, McGeorge ends up being the central player in the California marriage drama, which is why we're calling, well, you'll see what I'm calling the lecture. So there's a preview.
So I think we'll get started in about 2 more minutes. I think we've gotten to a good number. You had underguessed the number of my faculty colleagues who would come here, Bill. We got a nice turnout from the faculty, and I also saw that our editor-in-chief of the law review is on here somewhere, but I misplaced her. Ah, there she is.
There she is.
Hi, Kara.
Hi.
I don't know if Meredith is here, who's the current president of Lambda, but our past president, Will Finkel, is here. So hello, Will. Thank you.
All right, let's go ahead and get started. I'm Michael Hunter Schwartz, and I'm the current dean for 10 months and about 2 weeks of the McGeorge School of Law. And I want to welcome you to the 13th event of our 100th anniversary celebrations. And want to thank you for being here tonight. I want to thank my faculty colleagues and the students who are here tonight, and my staff colleagues. We're really thrilled that you're here. And our alumni, and a mix of other supporters. So thank you all for being here. It's my great honor to introduce tonight's speaker. I will say that there may be one or two spaces left for Friday night's debut in the Dolby Experimental Theater of our 100th anniversary film in San Francisco. So if you wanted to do that and you weren't able to do it, there still may be space there. All right. Here's my introduction. I want to make it clear that Professor Eskridge instructed me to do a much shorter version than I'm about to do. Professor William Eskridge is the Alexander M. Bickel Professor of Law at Yale Law School. He had received his BA from Davidson College in 1973, his master's in history from Harvard University in 1974, and his JD from Yale Law School, where he was the note and comments editor of the Law Journal in 1978. After clerking for Judge Edward Weinfield and practicing law at Shea and Gardner, he became a law professor. His primary academic homes have been the Georgetown University Law Center and the Yale Law School, but Professor Eskridge has also taught at NYU, Stanford, Toronto, Pennsylvania, Harvard, Columbia, Virginia, and Vanderbilt. His primary legal academic interest has been statutory interpretation. Together, Professor Eskridge and Professor Philip Fricke, a friend from Shea and Gardner, developed an innovative casebook on legislation. He also has published Dynamic Statutory Interpretation, Harvard University Press, 1994, and several dozen law reviews, many with Fricke, on statutory interpretation theory and practice. Pertinent to today's talk, from 1990 to 1995, Professor Eskridge represented a gay couple suing for recognition of their same-sex marriage. Since then, he has published a field-establishing casebook on sexuality, gender, and the law with Nan Hunter, which is in its 5th edition, 3 monographs, and dozens of law review articles articulating a legal and political framework for proper state treatment of sexual and gender minorities. Professor Eskridge's recent books include Marriage Equality from Outlaws to In-Laws, Yale University Press, 2020, which won the ABA Silver Gavel. He is holding it up for your viewing joy. Interpreting Law, a primer on how to read statutes in the Constitution, Foundation Press, 2016. A Republic of Statutes, the New American Constitution, Yale 2010, and Dishonorable Passions, The Crime Against Nature in America, 1861 to 2003, Viking Press, 2008. Finally, Professor Eskridge has been a wonderful friend of McGeorge, at which he has spoken by far more than any other scholar who has been ever visited our law school. And his graciousness and kindness are the only qualities that rival his excellence as a scholar. Professor Eskridge, I'm muting myself.
Thank you so much, Dean. Can everybody see the PowerPoint, which
Yes.
Judy has helped me
Yes.
share? I'm very honored to be a Centennial speaker, and I'm very happy that McGeorge has reached 100. I like to think that I might reach 100 myself in a few more decades. As you see, the title of my lecture, and it's going to be an article in the Pacific Law Journal, is called McMarriage Equality. And the inspiration from it, I'll return to him, is Michael, one of your predecessors, Dean Gordon Shaber, who was dean for like an eye-popping 34 years, which seems unimaginable in today's thing. Now, here's the theme of my talk. I'm going to go back to Dean Shaber, is that what you could call the marriage equality debate, California is overwhelmingly the most important situs of that debate in ways that we'll explore in today's lecture. And interestingly, at the center of the debate is McGeorge, the McGeorge Law School that is now celebrating its 100th anniversary. And at the center of McGeorge is Dean Shaber, who shaped McGeorge into what it has become, shaped hundreds, I think probably thousands of law students, and assembled an excellent faculty, which literally transformed the face of public law in America. So those are going to be my claims. And slide, what's distinctive and interesting about McGeorge is that it supplies both sides of the debate. That McGeorge alums led the campaign for California to head off same-sex marriage, California being a ripe state for that movement, which I was a part of. But at the same time, a McGeorge donor exemplifies why same-sex marriage, I think, was going to ultimately prevail. And one of your professors is the critical person who delivers marriage equality to the entire country, and I might add, also to California. Now, let me start with the skeptics of marriage equality. And a premise of today's lecture is going to be, and this is a premise of my book, that this was a very serious debate. This is not, in my opinion, a good versus evil kind of situation. This is a legitimate public policy debate. And the leading skeptic is a 1999 graduate of McGeorge. Now, admittedly, this is slightly after Dean Shaper's deanship. So Andy Pugno did not study under Dean Shaper. But very importantly, he continued in a major tradition that Dean Shaper established. And that is that Dean Shaper encouraged the students at McGeorge to work in the California government, even while they were students at the law school, and to serve the public interest. And that's exactly what Andy Pugno did. During his years at McGeorge, he was working for Assembly member and later Senator Pete Knight, a conservative Republican from Palmdale, and a leading figure in the geopolitics of California in the 90s and early part of the new millennium. Pugno and Knight shared many values, including a Catholic faith, and including an anxiety about what they accurately perceived as an ascendant challenge to the traditional understanding of marriage, at least in this country, of a union between one man and one woman. Now, Pugno, being a law student, Pete Knight, I'm showing you there, that's not his Senate uniform. He was a big hero in the Air Force and set a number of records. And I think that's probably the neatest photo that I can find of him. Pete Knight was not a lawyer. Pugno was not a lawyer either, but he was a very diligent law student. And while he was working for Pete Knight, it looked to the country like marriage equality was going to come to the state of Hawaii. There was litigation in Hawaii. The Hawaii Supreme Court had ruled in 1993, very early on, that it was a discrimination because of sex and a possible violation of ERA for same-sex couples to be excluded from the institution of civil marriage. In 1996, the case was on remand to Judge Kevin Chang to actually have a trial on this issue. Could the state justify this kind of discrimination? And so the New York Times and other hysterical journals waived this issue as a very important issue, and a lot of Americans were very upset. Among them being President Clinton, who had been elected with a lot of gay support. Well, President Clinton joined the Republicans and a lot of Democrats as well in throwing over gay people and supporting the Defense of Marriage Act in 1996. It was proposed by the Republicans. Clinton fulsomely signed on, and it passed by huge margins in both the House and the Senate. And I believe Clinton signed it in September of 1996. Now, by the way, usually when a president signs a piece of legislation, he surrounds himself with the people who benefit from it. And it's not clear whether which of Clinton's mistresses or the various wives that his co-sponsors had, were beneficiaries of the Defense of Marriage Act. Since Bob Dole, the one in the Senate, was divorced, Newt Gingrich was thrice married, and all of them cheated on their wives. But be that as it may, Clinton did save marriage, he thought, from committed lesbians raising children. And at the state level, Pugno warned Knight that all this stuff that Clinton is up to in Washington, this is going to do you no good. And Knight, why is that? And Pugno says, choice of law. We have a choice of law statute here in California. And California, by statute, will recognize marriages elsewhere in the United States that are valid in the state of their celebration. And so if Hawaii, this Judge Chang in Hawaii, requires the issuance of marriage licenses, and that's upheld on appeal, then California couples can fly to Hawaii, which has a minimal residency requirement. They can combine a vacation in Hawaii, so their honeymoon, with a valid marriage ceremony in Hawaii, and they can come back to California. And California, by statute, will have to recognize marriage equality. Well, Knight says, well, this is no good. And so Pugno draft me a statute. And Pugno drafted a statute which could be adopted by the legislature. This is, AB stands for Assembly Bill 1982. The bill got through the Assembly, but it died in the Senate when an amendment was added that would have recognized domestic partnerships. And that was a poison pill from the point of view of the supporters of the Knight Bill. And so the bill quietly died in the Senate after that amendment. Now, interestingly, at the same time that's going on, the Congress and Clinton are moving toward the Defense of Marriage Act, and California is considering, but ultimately killing, AB 1982. The Supreme Court drops a bombshell no one was expecting. And that's the decision in Evans and Romer versus Evans. In that case, the court, for the first time in its history, struck down a state law, it was a constitutional initiative, that penalized lesbians, gay men, and bisexuals. And the Supreme Court, in a 6-3 majority, said that this initiative, which targeted gay people for special discrimination, was a violation of the Equal Protection Clause. That had never happened before. And indeed, the leading Supreme Court decision on gay people was Bowers and Hardwick, where the Supreme Court just 10 years earlier, in 1986, had said that consensual private homosexual sodomy could be made into a felony. And in Georgia, you theoretically could get 20 years in jail for consensual private activity. Well, the majority in Romer versus Evans politely ignored, did not cite Bowers and Hardwick. And so the status of discrimination targeted against gays and lesbians, and maybe same-sex couples, is that maybe problematic. And they worried about that in Congress, and they worried about it at least a little bit in California. Now, what's interesting, of course, is that the opinion in Romer versus Evans was delivered by a McGeorge professor, or maybe more accurately, a former McGeorge professor, though, as we will soon see, he was still a McGeorge professor, Anthony Kennedy. He had been a successful practitioner. He was a protege, even as a practitioner, of Dean Shaber. That's Kennedy on the left, that's Dean Shaber on the right. And Dean Shaber, I think, circa 1965, persuaded Kennedy, hey, come and be an adjunct and regularly teach at McGeorge and teach constitutional law, et cetera, et cetera. Now, when Kennedy became a circuit court judge, I believe he still continued to teach at McGeorge in the regular semester. He had to leave that particular avocation when he was promoted to the Supreme Court later in the decade. And in my opinion, Dean Shaber was a direct as well as indirect inspiration for Justice Kennedy. Dean Shaber always stood for inclusion. He was a closeted gay man, but very lightly so. Now, here's an anecdote. This is a much later picture of Justice Kennedy, Anthony Kennedy, and his wife, Mary. And I encountered them several times at social events at the Supreme Court. And at one of them, before the pandemic, I asked Justice Kennedy's wife, Mary, she and I were just talking over in the corner. And I said, oh, you know, I've come across this wonderful video of Dean Shaber's retirement where Tony gave this wonderful address praising Dean Shaber. And she just lit up like a Christmas tree. Oh, yeah, Dean Shaber, how much they loved him, blah, 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 and how blah, blah, blah. So Tony sees Mary and me talking very intensely, and he comes over and Mary says, oh, you know, Bill is talking about Dean Shaber, blah, blah, blah. And Tony says, well, you know, I delivered all those remarks without notes. All right, Justice. And so we're talking in a very friendly way. And then I say, sort of say, by the way, did people realize that Dean Shaber was gay? And Mary piped up, she said, well, it was sort of assumed, but it was not something you talked about. And her husband, Tony, who's taller than both Mary and me, sort of scrunched up his face as he would do. And he would say, yes, it was irrelevant. Well, that's in my book. I think it's actually very telling. This is not a justice who preached gay is good, you know, that homosexuality is the salvation of the family or anything like that. But it was someone who said, okay, race is irrelevant. I think he would come over to the view that for most positions, sex is irrelevant. And his view was that whatever you were in your private life, that was irrelevant to your ability to contribute to society, to flourish, to have jobs, to have families even, maybe. Okay, and I think that's where Romer and Evans came from. It came from Justice Kennedy's view that he was either irritated or infuriated by the proposition that the state would single out people based upon this private characteristic and penalize them in large ways. Now, no one at that point, except for me in my books, was drawing the link between anti-gay discrimination and the marriage issue. And so the political system kept rolling along, and marriage equality kept rolling along, even though we did lose in Hawaii and in Washington, D.C. But we won a partial victory in Vermont in 1999, and we filed a marriage lawsuit in Massachusetts, where we were optimistic. Well, Punyo and Knight were like, this is not going away. The California legislature, now controlled by liberals, is not going to do anything for us. So in California, as you know, you can do statutory as well as constitutional initiatives. And so Punyo and Knight, Punyo wrote this. He said, going to do an initiative to add this new section to the family code where only marriage between a man and a woman is valid or recognized in California. So a new choice of law statute. Punyo ran a good campaign with heavy involvement, interestingly, from the Church of Jesus Christ of Latter-day Saints, later on them, and they won by a landslide, 61-39. Product of a smart campaign, but also the fact that public opinion was overwhelmingly skeptical in California and almost everywhere else of should the state recognize relations between gay and lesbian couples in the same way that they recognize civil marriages. Nonetheless, notwithstanding DOMA, the Clinton betrayal, Proposition 22 in the year 2000, notwithstanding all of that, marriage equality doesn't go away. And indeed, in the legislature, and California is really pathfinding here, in the legislature, the first four openly gay or lesbian members of the legislature were four women. And three of them, Senator Midgen, Senator Kuhl, and Assemblymember Goldberg, year after year after year would pass laws recognizing or expanding recognition of domestic partnerships. And they started in 1999, and it culminated in 2003, where Assembly Bill 205 sweeps through the legislature, is signed, and it gives almost all of the legal rights and duties of marriage, civil marriage, to lesbian and gay domestic partners who register with the state. So it's not marriage, and it's not even quite all of them rights of marriage, but it's what I call equality practice in an earlier book. Well, Punyo and Knight, Punyo is no fool, said this is inconsistent with Proposition 22. You know, if it looks like a duck, if it walks like a duck, if it quacks like a duck, it's marriage, even though they might want to call it with this euphemism. And so Punyo establishes the Proposition 22 Legal Defense and Education Fund, and he and lawyers from ADF bring a suit to overturn the 2003 Domestic Partnership Act, the expansion to create a virtual marriage equality. Now, ironically, Punyo and his allies are thwarted by another McGeorge alum. Here you go. The Attorney General, Bill Lockyer, was the year that Punyo graduated with great distinction and Order of the Coif in May of 1999. Attorney General Lockyer was the keynote speaker, was the graduation speaker. And he was, of course, class of 1986 from McGeorge. Lockyer is a really smart attorney, and Lockyer uses the Proposition 22 ballot materials to sustain his defense of AB 205, the domestic partnership law, and said, well, look, when the Knight Initiative was being considered, they distanced that from domestic partnership. There was a domestic partnership law, very minimal one in 1999. And they said, well, this is not the same as domestic partnership. We're not taking rights away from lesbian and gay couples. We're just merely protecting marriage, which is a very good argument. But it did come back to bite them. And McGeorge alum Jack Lockyer prevailed in that case. Now, we come to same year as AB 205, another landmark opinion, another opinion by Tony Kennedy. And this is Lawrence versus Texas, where Kennedy and five justices, Kennedy and four others, overruled Bowers and Hardwick, and a fifth justice says that Equal Protection Clause protects gay people, and says that gay people have the same privacy rights as everybody else, and that it's unconstitutional to make private consensual sodomy a crime. And it's a very sweeping opinion. Kennedy loved sweeping opinions. This is liberty. This is everybody. The gay people, it's irrelevant. Basically, it's irrelevant. Well, Justice Scalia did not think it was irrelevant. Justice Scalia thought this was a culture comp. And Justice Scalia, in ways that only he could do, lambasts the Kennedy opinion for requiring that gay men, lesbians, and bisexuals be treated basically the same, with the same privacy rights as everybody else. And true to his provocative nature, Justice Scalia argues that this is a signal that there are 5 or maybe 6 justices on this pretty conservative court who have signed on to the homosexual agenda, which he darkly hints is like this conspiracy by the homosexuals and their allies. And he specifically closes his dissent, and next is homosexual marriage. And that's it. Oi. So the McGeorge alum, Kennedy, delivers marriage equality, but there's another McGeorge connection. So Kennedy goes to Washington, and Dean Shaber is unrelenting. And Dean Shaber says, okay, you can't teach at McGeorge anymore because you're in Washington. Why don't you teach every summer in the Salzburg program that McGeorge runs over in Austria? Now, this is a picture much later of Mrs. Kennedy and Justice Kennedy at the Salzburg program. And this is another conversation I had with the Kennedys. And I asked them sort of about Lawrence. And Tony said, well, you know where that came from? I said, no. And Tony said, so I was teaching in Salzburg for McGeorge. And I was paired up with a European scholar of some sort, either a scholar or a judge. And we read the Dudgeon case, which was a European decision on consensual sodomy. And we read Bowers, which of course he already knew about Bowers. And Kennedy says, I was ashamed of my country. Dudgeon was that it talked about here is the price that is paid by human beings and lesbians and gay people by being labeled presumptive criminals. And the court should notice that. And the Dudgeon court does notice that, and they struck down, I think, a Northern Ireland statute, which made it a crime. And certainly that experience, Kennedy was determined to overrule Bowers and Hardwick. So probably when he decided Romer and Evans, and Scalia said, well, this is inconsistent with Bowers. And Kennedy would say, well, good riddance. We're going to bide our time. And I'll be damned if that remains on the law books of the United States, as it did not after Lawrence. Now, right after Lawrence, Massachusetts starts issuing marriage licenses. But that's not the headline grammar that here you in California are. Remember the Winter of Love? Well, the students don't remember that. Dean Schwartz remembers the Winter of Love. It was February and March of 2004. You recognize that dude in the center? That's Gavin Newsom, your current governor. And then right in front of him are the world's most famous lesbian couple, Del Martin, Phyllis Lyon, the founders of the Daughters of Bilitis, and legendary Californians. They, I believe, were the first couple to be Newsom married. Newsom said, we're going to start handing out marriage licenses in the city of San Francisco. Well, Andy Pugno says this is pretty lawless. Okay, you've got these happy lesbians. Everybody seems very happy. Newsom seems very smirky. But Pugno says this is very lawless, right? And so his Proposition 22 LDEF fund brings suit to overturn these Newsom marriage licenses. Well, it doesn't get anywhere until Attorney General Lockyer, there he is, right on the left, McGeorge alum. The McGeorge alums come together, and Lockyer petitions the California Supreme Court, say, well, this is all very lovely what they're doing, but it's all very lawless. And these marriage licenses need to be invalidated and they need to be stopped. And by 6-1, the California Supreme Court agrees. And so the combination of Lockyer and Puno ends that. But remember, this is like the Terminator. You know, Arnold Schwarzenegger, it's Terminator. Marriage equality just won't die. It just keeps chugging along. And so the Puno lawsuit continues because they were seeking a declaratory judgment that the state bar, like Prop 22, was constitutional. After Lockyer, the people on my side, gay and lesbian groups, and San Francisco, I might add, filed separate lawsuits to overturn the marriage bar as inconsistent with only the California Constitution. They don't raise federal constitutional issues. Very, very smart. Attorney General Lockyer, McGeorge alum, class of 86, and his successor, he rotates out, I believe, in 2007, and becomes, I think, treasurer of California. Very popular guy. They defend the exclusion, not as vigorously as some would have wanted. Puno and his group defended more vigorously. And in, I think, May of 2008, the California Supreme Court heard argument in the consolidated marriage cases. All the cases scrunched together, same appeal, with the state represented, Puno's group represented, plaintiffs represented, and so on. Puno was right there. You know, this is his case. And he saw that all was lost. The conservative justices looked very sour, and the Chief Justice, who was the key vote, looked like the cat that caught the canary. And so, but Puno, very diligent, McGeorge alum, Order of the Coif, he's planned ahead, like a very good lawyer. And earlier than the California, the argument was made, I think the decision was handed down in maybe June, soon after. He already had created a thing called protectmarriage.com, which was an organization which was going to sponsor a voter initiative to amend the California Constitution. Remember, Prop 22 was statutory. It takes more signatures to get on the ballot to amend the Constitution. He said, we're going to go to the Constitution this time. And this was ultimately going to be called Proposition 8. There's Andy in front of the Yes on 8 and protectmarriage.com. Now, here's the problem. So he had won a great victory in 2000, but in 2008, it was going to be very much more difficult to win a constitutional initiative in 2008 than to have won a statutory initiative in 2000. Public opinion had changed. In other books and articles I've documented, Massachusetts started handing out actual marriage licenses, not these Newsom ones, in 2000, I think it was May of 2004. Every year after that, the percentage of Americans favoring marriage equality went up, the percentage opposing went down, and by 2008, the lines were getting ready to cross nationally, and maybe we're about even or crossing already in California. And the gayocracy, my side, was not as well organized in 2000, was very well organized in 2008. You have celebrities, you have money, you have organization, et cetera, very well funded. And what's going on? The presidential election, Obama's the candidate. He's going to sweep California. So it's all looking very good for my side, except that Andy Puno is really smart. And among his many smart things, I'm going to show you some smart things that he did that only a good lawyer would do. And the smartest thing he did was that he and his allies wooed Jesus Christ of Latter-day Saints, which is mainly Utah, but has a lot of Californians, to return to the campaign. And there we have another McGeorge alum, Elder Whitney Clayton, McGeorge, class of 78, and a major figure in the Church of Jesus Christ. Brief anecdote here is that Punyo and his allies, they're Catholics, but they've got to get the Latter-day Saints on board. So at least, by my book, 2 Catholic bishops or archbishops wrote their buddy, the president of the Church of Jesus Christ in Salt Lake City, hey, code blue or whatever on marriage. If you want to protect traditional marriage, you need to get involved. They got the president's attention. The president sent Whitney Clayton, that's Whitney and his wife, McGeorge alum, on a fact-finding mission to California. They found facts. Hey, there's an initiative here. Hey, there are gay marriages here. Hey, there's Andy Punyo here. And they came back and said, this is something we ought to invest in. And the church invested. And wow, did the church invest. This is just a flow chart of the Proposition 8 organization. And as you'll see, the Latter-day Saints dominate pretty much. You got your coalition leadership, that's Punyo and his buddies over on the right. And Frank Schubert is their campaign manager, brilliant campaign manager. But then the rest of it is pretty much Mormons. It's Mormons all the way down. And you see Elder Clayton is the liaison. He's appointed to be the liaison with the California campaign. And so you've got coordinating councils, you've got some money raising by the Mormons. And then Frank Schubert told me that he had as many, and Frank Schubert is a very factual guy. He felt there were as many as 250,000 Californians working neighborhood, et cetera, canvassing during the Prop 8 campaign. And he thought there were as many as 100,000 volunteers, these are unpaid for the most part, who were working for Prop 8, yes, on Prop 8, on Election Day. And somewhere between 80 and 95% of those were Mormons, delivered by Elder Clayton. Now, what else did Punyo do? Well, that was pretty important. Punyo also came up with advertising copy. In 1996, when he was still a law student, Punyo discovered he read the statutes. Who did that in those days? Nobody. You know, Ding, you said I wrote a statute book. No one was reading statutes. Supreme Court was not reading statutes. Scalia was, and I was, but that was about it. So Punyo actually read the California Code, and he said, look, the Education Code requires public schools to instruct on marriage. Y'all are pretty bizarre states sometimes, but that's what it says. And then in 1998, your legislature amended the statute to also say the code that public schools cannot discriminate against gay people. So you put them together, and Punyo says, look, Schubert, this means that if there's marriage in California, and not these Newsom marriages, but real marriages, the schools will be required to teach about gay marriage, and they're required to teach favorably. And here's the ad. This was a very famous ad, one of the most famous ads of the 21st century. A little girl, there she is, has been in public school. She's read King and King, which is, you know, romance between two men. And she comes up to her mommy and says, Mommy, I want to marry a princess. And then mommy looks confused, distressed, and defeated. And then that law professor over the left says, this is what's going to happen if you get marriage equality. Wow. Here are the tracking polls. This is the tracking polls from my side. These are not from the Punyo side, I don't think. The tracking polls from my side is that when the Two Princes ad was aired in early October, and there was another ad, by the way, that's also a Punyo, and that is there was an ad called Newsom, where Andy had seen a video where Newsom gloats over the fact that there's now gay marriage. He says, you know, gay marriage is here, get used to it. He smirks. And so, you know, Punyo and Schubert came up with an ad called the Newsom ad, where Newsom is smirking, you know, gay marriage is here, get used to it. You know, whether you like it or not, Well, that had an immediate effect on public opinion, particularly on the effect of mothers with children at home. Whereas before the ads, in early October, they were very strongly against Prop 8. They turned around immediately. And the ads had something to do with it. Congratulations, Puyo. Okay, and so they win. Yes, Proposition 8 ultimately wins. So they're challenged, as you know. There was actually a state constitutional challenge, and Puyo very intelligently retains former Solicitor General Ken Starr, very talented attorney, and I think he was dean at Pepperdine at that point, to represent the supporters of Prop 8 and Strauss versus Horton. And I think 6-1 majority of the California Supreme Court agrees with Puyo and General Starr. The day after the California Supreme Court rejects the state constitutional challenge, Ted Olson and David Boies file a federal constitutional challenge in Perry versus Schwarzenegger, your governor. Puyo says, well, I don't believe the governor and the attorney general, who I think was Jerry Brown at that point, I don't think they're going to vigorously defend the statute. So my group is going to intervene. And Starr wasn't available, so he chose Chuck Cooper to represent the supporters of Prop 8. And exactly as Puyo had guessed, the governor and the attorney general and the other official defendants do not lift a finger in support of Prop 8. And the proposition is basically defended by Puyo's group. Now, this is the argument. This may or may not be the argument the way they would like to put it, but I think this is the argument, the best argument that was being made in the litigation, not in the political campaign. It's called the Jenga argument. I call it that. And you see, that's the way Jenga is played. I don't know if you've ever played it. There are no winners in Jenga. There are only losers. Is the person who pulls out the thing and the tower falls. That's the loser. So there are no winners, just the loser. And as anybody who plays Jenga knows, once you've taken out one thing from the base, that makes the tower a little bit more unstable. But if you take out two, the tower is going to fall soon, right? And the argument that was made in the Prop 8 case, so you can't make the argument that gays and lesbians are this or that or the other. That's not going to wash with Vaughn Walker or the trial judge or with Justice Kennedy. And you're not going to wash with the argument that marriage is for procreation, because everybody knows that it's not just for that. So their argument had to be the following, that civil marriage is very important, has already been weakened by no-fault divorce. No fault of the gays, but no-fault divorce. So that's the Jenga pile I'm showing you. One base feature has already been removed. If you remove another one, the pile will fall. Does everybody see that argument? Now, so that's the argument. Well, it didn't prevail. Okay, so shoot me. Judge Walker rejects it in a very lengthy 2010 judgment, finding Prop 8 unconstitutional. The Puyo group, the intervening defendants, the sponsors of Prop 8, take an immediate appeal. They lose in the Ninth Circuit again. And then they get the Supreme Court's attention. They go up to the Supreme Court, where, to their great frustration, they lose on standing grounds. And the fifth vote is Scalia. Ugh! What a terrible way to lose. Kennedy's in dissent, as I would have been. Kennedy said, no, they're standing for these people, the sponsors of Prop 8. They ought to be able to defend it if no one else will. Oy. So immediately after that, so that means that the appeal was non-justiciable. Supreme Court dismisses the appeal. The Ninth Circuit judgment is vacated because no standing there. But Judge Walker's judgment is left standing because they had standing. It was justiciable. Plaintiffs were harmed. Defendants were defending. And so California immediately issues marriage licenses again. Now, the same day, a different 5-4 court invalidated the Defense of Marriage Act exclusion that permanently excluded same-sex marriage couples from federal marriage law and spousal law. Kennedy wrote, naturally, and he rejects the Jenga argument. And Scalia, again, is furious. And Scalia says in dissent, he says the majority, even though it's striking down this federal statute, Scalia says in dissent, that this is a roadmap. And he actually edits the Kennedy opinion in a very smart way, which shows just to change a few words, and you've got a marriage equality opinion under the 14th Amendment. And Scalia says same-sex marriages are on the way. Well, that was a blunder, because now Windsor was June of 2013. In 2014, district court after district court. So the LGBTQ folks, me and all my buddies, were turned loose to litigate in every jurisdiction in the country that doesn't already have same-sex marriage. And we just start winning case after case after case at the trial level. And a bunch of them go up on appeal. And there are, in the middle of 2014, there are 4 circuits that affirm the trial court judgments of unconstitutional. The 4th Circuit, which is Virginia and those states. The 7th Circuit, which is Judge Posner, it was Wisconsin and Indiana, there you see. The 10th Circuit, there was a Utah statute and Oklahoma statute. And then the 9th Circuit, a few days later, I think has Idaho and Nevada. You all are in the 9th Circuit. And on October 6th, and most of them cite the Scalia dissent, say, well, it's all over, and we just don't think the state has any good justifications. They don't accept the Jenga argument. So in October of 2014, the Supreme Court, with Kennedy leading the way, denies review in all of the circuit court appeals. So that meant that not only Virginia, but all the states in the 4th Circuit are going to have to recognize marriage equality, which they did pretty quickly. All the states in the 10th Circuit, like Kansas and Wyoming, are going to have to recognize marriage equality. And in the 9th Circuit, you lump up Alaska, Montana, as well as Idaho and Nevada and Arizona. So my side went on October 5th, we had 19 states, which is a lot for us, recognize marriage equality. After the Supreme Court's denial after denial, we ended up with 35. Well, okay. And then there finally is a decision going the other way in the 6th Circuit, which is Michigan, Ohio, Kentucky, and Tennessee. And then the Supreme Court grants review, but it's marriage equality in a very colorful display by the Supreme Court. And who writes it? Can you guess who writes it? Well, it's Tony Kennedy, the McGeorge guy, the Salzburg guy, the Shaber protege. And they're very smiling. They're very smiling, and they're delighted. And Justice Kennedy, does that. Now, here's the final question, then I'm going to stop. So when did Justice Kennedy decide for nationwide marriage equality? Because this is not like a big champion of gay rights or anything like that. And it's not clear. But here's my likely answer. My likely answer is, and this is a McGeorge answer, he was committed all along to the notion that sexual orientation is irrelevant, the word he used to me, and that Dean Shaber impressed upon him, irrelevant to people's capacity for citizenship and contribution to the community. And that people of sexual orientation minorities, sexual minorities, and I'm sure he would include gender minorities, deserve the same rights as everybody else to lead flourishing lives without state interference. And Kennedy was unimpressed with the Jenga argument, probably from very early on, particularly once all these states start granting marriage licenses. And there are no bad consequences. There are no low. And Kennedy can see that. Moreover, and this is where McGeorge comes back into play, Kennedy was aware all along, as a Sacramento person and as a McGeorge person, that male-male and female-female couples did form committed, lasting relationships. I've worked on this for 35 years, this issue. And looking back on it, the big impediment and the reason why I was in the minority for most of this time was that most Americans, including most progressives and tolerant people, felt that, well, gay and lesbian people don't really need marriage. They're not really serious about this. This is a publicity stunt, or it's symbolic, or this, that, or the other. And the reason my side won is that once we got a beachhead in Massachusetts and then California to some extent and other states, a lot of committed couples came out of the closet as committed couples, often raising children. And they looked like families, and indeed they were families. And people started saying, oh, this is actually kind of serious. Oh, and this actually doesn't undermine marriage. Oh, is there really any good reason not to recognize these things? Okay. And I think Kennedy was clearly a part of it. But even more specifically, the couple who might have been the biggest early benefactors from McGeorge, the benefactors in the Shaber era, was a gay couple whose relationship was known to Kennedy and other friends of Dean Shaber, and that's Perry Mason. Perry Mason was the commencement speaker in 1960 at McGeorge. He was a very famous TV actor. He was probably the most famous TV actor in the period when Perry Mason was a TV show, 1957 to 66. Then he later starred in Ironside, and then he made all sorts of Perry Mason movies. Well, he met, and by 1960 was in a committed relationship with Robert Benavides. And they were a discreet, same-sex committed couple, I believe, from 1960, if not earlier, to 1993, when Raymond Burr, Perry Mason, died. Raymond Burr, Perry Mason, was the MC at the dinner in November of 1992, celebrating Dean Shaber's birthday and his deanship at McGeorge, the same dinner where Tony Kennedy gave his tribute, which to this day he's very proud of, and justifiably so. And so, at least in my opinion, Perry Mason and role models, many of them probably associated with McGeorge, many of them not, were, I think, evidence all along to Tony Kennedy that this gay marriage thing was not a stunt, was not just symbolic, but represented the lives of people. And so I close, if I may, with the words that Perry Mason uttered on cross-examination of Dean Shaber at McGeorge in November of 1992. He was dying of cancer, and he uttered these words: "I've never met a woman or man in my life whom I admired more than Gordon Shaber. I've never met a man or woman who could charm you out of every dollar in your pocket." And Dean Shaber was a legendary fundraiser, but he did it all for the greater make good. And I wish you a happy birthday. End of tirade.
So you could all join me in applauding Professor Eskridge for his wonderful talk. So we have actually 6 minutes, because obviously my remarks went too long, because I know his did not. I
We can
think,
go beyond 5 o'clock, can't we?
yes, we can.
Okay.
And I will say, I'm not sure he will answer further Jenga strategy questions. So that would be about the only limit on the scope of questions. He might even be willing to talk about statutory interpretation, in which he is among maybe the 1 or 2, maybe 3 foremost experts in the United States, in addition to his, as you've seen, profound and extensive knowledge of marriage equality. So you can put your questions in the chat, or just I don't know, unmute yourself and ask.
Go ahead.
Well,
Can I go ahead and start? Thank you so much. That I loved, as a visiting faculty member, I loved hearing all of these connections with McGeorge in that whole story. But one thing that I was struck in a lot of Kennedy's opinions, like Romer and Lawrence, is his focus on dignity. And so I wondered if you could speak a little bit to that.
Yeah, I think there's a McGeorge connection on that as well. I mean, the answer is I don't exactly know, but dignity is a very European term. And remember, the Salzburg program, typically paired him with European scholars and judges. And Kennedy loved that. I can't overstate how much they loved the Salzburg program. And I know that he was regularly there from 1990 on, maybe even before, but certainly from 1990 on. And I believe from the way he described it, the big moment on Dudgeon and Bowers was either 1990 or 1991, very early on. And so dignity is a very European way of thinking about the treated. And Dudgeon, Rachel, I think is a very dignity-oriented opinion. And you see, I'm publishing an article, on this in the Pacific Law Journal, and I'll give like quotations from Dudgeon and the parallels between Dudgeon quotations and the Lawrence quotations. So yeah, and I think it's a great way of looking at it. I don't see equality and dignity as either or. I see them both and. I think equality is one way you dignify human beings, and respecting their liberty is another way you dignify human beings.
Thank you.
Larry.
Looks like Professor Levine.
Thank you. I'll jump in. So thank you, Bill. As always, that was just wonderful and extremely interesting. So I like to think that we've got another 100 years ahead of us, and that some of our students will be continuing to fight the good fight. And so let's talk a little bit about the fragility of marriage equality, even if we won't even deal with the other things unless you want to, but even dealing with marriage. With the current Supreme Court, do you think the McGeorge students today are going to have opportunities to redefend the concept of marriage equality in the not too distant future?
Well, as I'm sure you all realize, Dobbs, the abortion decision overruling Roe versus Wade, does call into question other privacy decisions, of which Obergefell, the marriage equality one, is a main one. Lawrence also versus Texas. I am dubious the Supreme Court, even the current group of justices. By the way, there's no doubt there are not 5 justices who would have voted that way, as Obergefell did. There are probably 3 justices today who would vote with Obergefell, and 6 who would have dissented, as the Chief Justice did. Remember, the Chief Justice is now in the left wing of the court. So, and I'm not even talking about stare decisis, because as you know from Dobbs, stare decisis is now a very attenuated, sort of sometimes it is and sometimes it isn't doctrine. But they do not like trouble. And if they're going to do regime change, they're going to do regime change on the backs of women and racial minorities. And I think it would create a lot of trouble for them to overrule Obergefell, because it would create a hornet's nest of criticism. And it would also create a hornet's nest of litigation, because then you would have married in some states and not in others. And how do you resolve it? And there'd be like endless litigation. And I think Dobbs is already producing that. So I think if I were an extreme right-wing justice, I would be concerned about Dobbs. So here's what they're going to do instead. I don't think they're going to, plus I don't think the right-wingers are going to go after overruling Obergefell. I think their strategy their allowances. And so I think we're going to see with the Roberts Court an expanding array of religious allowances, and not just for gay and lesbian people, but for others as well. And that's a way to dilute the effect of marriage equality, but without, actually getting a scream headline in the New York Times. Court throws all of privacy law into doubt, including Griswold, if they overruled, say, Lawrence. And do they really want gay people to be criminals again? I don't really think so.
Thank you.
So I think that's the way it's going to be. I think that's the way it's going to be. Others. Dean, you get to ask a question if you want.
Oh, well, thank you. Actually, Larry stole my question, but I will defer to Toby, and because I'm merely Dean.
Toby.
Hi, Professor Eskridge. It's great to see you and Professor Levine and everyone. I wrote my question in the chat because I tend to talk too much, so I figured I should write it down. So I'll just read what I wrote. I remember as a student trying to convince you and Professor Levine and anyone who would listen that marriage equality should be one based on gender discrimination, not sexual orientation discrimination. And I argue that as a bisexual that, you know, my my sexual orientation doesn't change, but I can marry a man, but I can't marry a woman. Um, and I filed an amicus brief on that argument in Obergefell. How do you feel now about the terms on which Obergefell was won?
Well, I personally, I filed a brief too, making the sexual orientation and actually just the rational basis argument. I filed an equal protection brief. I felt that it violated the original meaning of the Equal Protection Clause, as explained by Senator Sumner and other, abolitionists. So, and I was on record at that point, by the way, Toby, in favor of the sex discrimination argument for gay rights. But that was not my brief. And I will also say this: Chief Justice Roberts asked about your argument in Obergefell's oral argument. Roberts asked the states to say, well, what about the sex? Why is this not a sex discrimination? And wow, did that come out of left field for the Chief Justice? Because remember, he ultimately joins Bostock. So you really got him thinking about that. And I might also add, I think in either Hollingsworth, I think it was in Hollingsworth, Kennedy had asked about the sex discrimination argument back in 2013. So they've been kicking it about. Now, the terms on which Obergefell won, here's some gossip. No, this is fact. Okay, there are 9 justices, right? At conference, there were 3 justices, who were definitely going to vote no rights for the gays, no marriage equality. We didn't know how Roberts was going to vote, but he fell into line with those 3. There were 4 justices at conference who said this violates the Equal Protection Clause. There was 1 justice who said, I don't care about the equal protection. I think this is a liberty denial. Okay? And that 1 justice wrote for the court. So Attorney General or Solicitor General Verrilli was surprised. I was surprised. You were surprised. The gayocracy was surprised. That it went off on the fundamental right to marriage. And, there was a lot of negative pushback against that when the decision was announced. Kennedy read the opinion in open court, and there was a chilling moment when he was reading, a short version of the opinion, where he says, talking about it's this really panegyric to marriage, which the Kennedys really believe. So again, he's not like a progressive. He's a pretty conservative guy. And he's saying, marriage is like this existential thing. And if you wake up in the middle of the night, you don't have your spouse right there, this is about as lonely can be. So he reads that line. It's paraphrased. Every guy member of the court is married. Every female member of the court is not. Ginsburg was a widow, Sotomayor had divorced, and Lena Kagan had never married. Can you imagine how those women and how other women as well, and not just feminists, but how those women felt? And I'll also tell you this, because Ginsburg was a friend of mine and she gave me all sorts of good stuff about Obergefell, is that, so I asked her, I said, so did you really just have to do this liberty opinion? And she explained to me, she says, now, Bill, we had a deal. Is that in these cases, Tony would speak for all of us. No concurring opinions. That was the deal. Okay? Now, I'll give you gossip. This is not my book because I can't verify this. I was told that the week before Obergefell was handed down, Elena Kagan circulated something to the conference, and within minutes. And my speculation was that she was circulating a concurring opinion, just wanting to say something. And Ginsburg had called her up and said, withdraw it immediately. And when Ginsburg gave you an order, you said, yes, ma'am. Now that's speculation. I don't really know that. But what I do know is this, and that is that Kennedy circulated his opinion. And if you're Ginsburg or whoever, and Ginsburg was the ringleader, if you're Ginsburg, do you really want to take on this like wake up in the middle of the night moment? Because apparently that was important to Tony Kennedy. And she said, no, what I really wanted to do was to inject some equality language into this opinion. The original opinion was just liberty, 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 marriage, marriage, marriage. And there are about 6 or 7 paragraphs in the opinion now that are equality paragraphs. And they're either written or mostly written by Ginsburg and then sold to Kennedy. And the way she sold it was, now, Tony, you got so much acclaim in Lawrence for the way in which liberty and equality interacted. And don't forget Dudgeon. That's what Dudgeon did. Dudgeon. And Kennedy was like, oh, yeah, McGeorge, Dudgeon, da, da. And so he'd done this in Lawrence, again, at Ginsburg's suggestion to some extent. And Dudgeon does this in the case, the McGeorge case. And so some of that stuff got woven into it. Now, again, it is a fundamental right to marriage opinion. It is that. That's what it is. And most of the people who are wild about Obergefell are not wild about the fact that it went off on that. Now,
it was confusing. It was confusing to some of us reading it, sitting there reading it. The copies that were handed out, sitting there reading it. Oh my gosh.
Is this the majority?
Like, wait a minute, are we talking liberty? Are we talking equally protect? Yeah.
Well, it is. Yeah, it is confusing. It is confusing. On the other hand, a number of people, Melissa Murray, my wonderful former colleague, Melissa Murray, and others have argued that Obergefell is going to be fatal or deadly for the rights of unmarried people. And I don't agree with that. Indeed, since Obergefell, a number of states citing Obergefell, like Maryland, have actually expanded the rights of unmarried couples. Now, you could easily see how it could be used to contract them. I agree with Melissa Murray on that. But in practice, I think by normalizing committed relationships of people's choice. So Kennedy was very big on dignity, but he was also very big on choice. Well, by normalizing the idea of committed relationships based on choice, that opened the door, or at least left the door open for recognition of unmarried relationships, where there's unfairness, for one partner or something or another. And I wrote an article in the Georgetown Law Journal on their 100th anniversary on the way in which marriage law had changed, or family law had changed in the last 100 years. And one of the big points that I made is that a matter of statute and court decisions and whatnot, there has been a constant increase in attention for unmarried couples. So domestic violence laws typically apply to cohabiting couples and not just married couples and so on. You see a lot of second parent adoption laws or judicial decisions where unmarried couples, straight, gay, whatever, unmarried couples can, say one of them has a kid, the partner, even though they're not married, can be a second parent to that kid. And then you've got, very difficult cases where there's some inequity. A partner is deserting another partner who's relied on their household to sacrifice their employment or even educational sort of things. And those are the heartbreaking cases. And of course, as in everything else, California is almost always in the leadership role here in thinking about. In California, I think you can have 3 parents now, theoretically, under statute. So California
That's
is,
been going on for 10 years, and that's what I do. That's
yeah.
my whole law firm. That's what I do. It's just me, third parent parentage judgments all day long.
Well, I call it, you can reject this if you're entitled, I call it polyparenting.
It is.
It's polyparenting.
It's polyamorous families getting parental rights for their children that they're raising together.
And California's not alone. DC now allows it, and others, increasingly states are. Courtney Jocelyn of Davis, just down the road from you all, has written on this magisterially. She's I think the reporter for the either model statutes, the ALI or something. Courtney Jocelyn is very important on this, and etc. Okay, that was great. Any other questions or statements or experiences?
I thought I would, since you invited me to have a question. I'm going to try to articulate it, maybe because I have this excessive optimism disorder, that I am wondering whether the Gorsuch's opinion in Bostock might have some seeds that since the Chief Justice also bought into it, that might create a survival possibility for Obergefell.
Well, of course, that's Toby's question, it seems to me. And I did a brief in Bostock. I totally, ran the Toby kind of argument. And I think, but here's the problem. And there's a case that's actually going to test this right now, Dean. The Skermetti case. I'm involved in that one. I just filed a brief in that one, where Tennessee has a very broad statute singling out transgender folks under the age of 18, that they cannot get needed medical care required by the medical protocols, even with parental consent. And Tennessee, oddly enough, way more than California, Tennessee has statute after statute, including one that was passed just a few months ago, saying parents have absolute rights to the health and education of their children. State cannot intervene, period. Compelling interest, nothing else, Statute after statute says this. Except for if you're the parents of transgender children. Also in Tennessee, if you have cisgender children, you can get hormone therapy for what they call precocious pregnancy, no problem. Oh, not precocious pregnancy, precocious puberty, no problem. You want breast reduction? You can do that in Tennessee if you have parental permission. Breast enlargement, easy peasy. Rhinoplasty, which I think is nose, whatever earplasty is, or toroplasty, whatever that is, all that. Not if you're transgender, but if you're cisgender. Hey, how about birth control pills? Birth control pills have hormone in them, right? That is forbidden to transgender kids, even with parental permission. Whereas, of course, non-transgender kids who are unmarried and get pregnant, if they get parental permission, easy peasy in the state of Tennessee. Okay, so Supreme Court granted review only on the equal protection issue. And I'd done a brief in the Eighth Circuit on due process liberty. So I converted our Eighth Circuit brief into an equal protection fundamental rights brief, which is in Tennessee, parents have fundamental rights. Under the Supreme Court precedents, parents have a lot of rights. Children do too, in my opinion. And here they're aligned. The only parents who don't have any of these rights are the parents of transgender children. Right? Oi. Now, we're not a party. I'm just an amicus, just a law professor, Steve Calabresi and I. The U.S. government is the main petitioner, and the ACLU is the other main player. We are not main players. They're both running Bostock arguments under the Equal Protection Clause, right? I think, I'm not sure, I don't think Gorsuch is going to buy it. Gorsuch writes Bostock. And I think what Gorsuch is going to say, he said, look, Bostock, we had a statute says discrimination because of sex. I don't know that Gorsuch accepts the sex discrimination equal protection cases. And I'm not sure Roberts does either. So my view is the reason we're filing the brief, or we did file the brief, is that I think there are 3 votes for the Bostock argument. Dean, exactly as you say, you can count to 5 rather easily, but that means that Gorsuch and Roberts have to stick to it, but apply it from Title VII to the Constitution. And that's a heavy lift for these critters. So my view is, I buy the Bostock argument for Toby reasons. But, we're diversifying our portfolio, or trying to anyway, by making a kind of argument that, say a Roberts or Kavanaugh could maybe join. And it's just so obvious. It's so obvious. The Tennessee legislature, I don't know what Nimrods inhabit the Tennessee legislature, but they pass all this anti-trans stuff. And then the next year they pass this vast, parents have all these rights, all these rights, all these rights, all these rights, all these rights. But under the earlier bill, parents can be criminals. So it's not just doctors can't do needed medical procedure. And by the way, people who are having hormone therapy now are cut off. The statute makes doctors who help them criminals, and it makes their parents criminals. If the parent of a transgender kid who's cut off of hormone therapy by the state, if that parent enables them to have hormone therapy, that parent can criminally be prosecuted in the state of Tennessee. And it's just breathtaking. From a conservative point of view, it's breathtaking. Well, anyway, the point is that I think the chambers, this is what I'm told, the Gorsuch chamber is having a little bit of buyer's regret, because remember the feature of the U.S. Supreme Court, it is an echo chamber. Whom are they hearing from? Well, Kavanaugh and the chief talked to me some, but they're mainly hearing from Fed suckers. Their clerks are all Fed suckers. And the echo chamber is sort of like the Fed sock really reacted negatively to Bostock, even though I think a lot of the younger Fed suckers were okay with it. But conservative movement did not react very well. And to make it constitutional would, I think, be a big step for the likes of John Roberts and Neil Gorsuch. But something like parental rights thing combined with an equal protection thing, but we'll see. We filed our brief. The Tennessee has not filed its brief yet. And so we'll see what their brief looks like. But the United States makes a very good Bostock argument, straight down the line Bostock argument. The ACLU, these are both excellent briefs. And so, Toby, I recommend them to you. And they're an effort, obviously, an excellent effort in both cases to translate Bostock over into the Equal Protection Clause. And so there's nothing in our brief that's inconsistent with that. And we do sort of flog the classification horse a bit, but we completely endorse it. But ours is more of a historical brief on traditional parental rights. But it was always parental rights and responsibilities. The children always had legal rights under Blackstone, Cook, and all these critters. So it was never just parents have absolute rights. It was always parents have responsibilities, children have rights, et cetera, et cetera. So there's a view from a very discouraging place.
Yes. And I think that's probably where we're going to have to wrap, in part because my computer charge is now down to 5%. And so I want to thank you all for being here. I want to thank the brilliant Professor Eskridge for his fabulous presentation, and look forward to seeing those who are able to make it to San Francisco for our forthcoming event. Take care, everybody.
Thank you, Bill.
Happy birthday.
Thank
you.
Great seeing you all. Thank you, Mr. Professor Eskridge. That was
My
fantastic.
pleasure. Toby, thank you.
Pleasure.
Thank you, Larry.
No,
Thank you,
thank you.
Judy. Thank you, Dean, for
When are
hosting.
you going to be out this way, Bill? When are you going to come visit your sister?
Well, I almost always come out, as you know, around New Year's because we do a family vacation. We used to do it in San Francisco. I think we're going to do it in maybe Oakland this year. So I come out for New Year's, and then we go back to Sacramento, and I fly out of Sacramento to go back home.
Double ALS is in San Francisco, if that grabs you at all.
Yeah, I don't go to that anymore. COVID, I'm really